Well, Catherine, thank you very much. It is a joy to be here with you today. I was not a Boy Scout growing up, and it bears out today. My Solicitor General is here with me today. We didn't bring a coat to Washington, and I understand there's a snowstorm coming. Wow, that's ill preparedness, but we try to be more prepared legally on the issues that we deal with. I thoroughly enjoyed the professor's comments. Maybe we can do it online, Catherine. I don't know if we can do that as an extension course or not. I can't go to Indiana and attend Notre Dame class there at Notre Dame, but I thoroughly enjoyed your comments. And Anna, I understand that you were a student, and with the professor, your comments this morning were outstanding. I appreciated your comments. I want to start, and I am joined with my Solicitor General, Patrick Wyrick. We had two cases this past year in 2013 that many of you know were on the way. In fact, the court actually took jurisdiction of one of those cases in the Nova case, and we thought we were going to be here before the Supreme Court this year, and ultimately did not happen. But Patrick's been a great champion with me, and as an extension of our office, fighting these issues on behalf of Oklahoma's interest and the interest of women and children, and really appreciate his partnership. I want to speak big picture just for a second, that I think when we come to gatherings like this, I think we need to be reminded this is more than an academic setting. These are fascinating topics that we're talking about. These are, I'm inspired. In fact, I was asking the professor as he sat down, I want to talk to you about one of the things that you mentioned, and perhaps we can unpack it later. But this is more than an academic setting. We need to keep in mind that these issues are big issues with respect to the lives of children and women. And we need to keep in mind also that sometimes we grow disheartened with respect to this battle that we're on. The professor mentioned Planned Parenthood versus Casey. I was in law school at the time. I know I don't look that old. I'm still vigorous and don't play baseball like I used to, but watch my kid play. But, I was in law school at the time, and there was a disheartening effect with respect to Planned Parenthood versus Casey. And I think this long journey that we've been on with respect to both state laws that are passed and the court battles that we see and the presidential elections that we engage in, we have all these various fronts, and sometimes when we lose or there's a setback, we get discouraged. And so I want to say to you one thing. Don't be discouraged. Don't lose the fire. Don't lose the passion. Think of that gentleman, William Wilberforce, that took on a great, great challenge during his century. And you know what William Wilberforce was about? He was about the abolitionist movement there in England. And the battle that he faced was no less a battle. Obviously, it's equal to what we engage in today. And so we've got to grow, I think, optimistic in our view. And that's part of what we're actually talking about with the laws that are being passed at the state level. These are optimistic. These are really laws that are being passed to advance the interest of both women and children, but to inform them and to help them make a decision so that when they're 20 years beyond that decision, they don't look back with regret. And that's important. So I wanted to first start there, and also wanted to say to you that General Douglas MacArthur had two questions he asked. He said, I read this in a book many years ago, he said, before you enter any battle, you should ask yourself two questions. Is victory believable, and is victory achievable? And the believability part is something that's very important, because that is the part that says we can go forward and make a difference. And sometimes that's the disheartening aspect where you draw back and you shrink from making the changes or advancing the changes. But the achievability part is really where I want to camp today. Because we've got to have a plan in place at the state level. And I see Dan in the back. You're all doing a great job in the state of Oklahoma. You're doing a great job across the country at working with legislators to inform and educate and to give them the plan on how to achieve what they can achieve from a policy perspective. So I really appreciate that, the partnership of AUL. I was actually in the legislature from 1998 to 2006, and at that time AUL was not on the ground. And so I really appreciate the addition of AUL across the country to the battle and to the focus of advancing life. I want to really address predominantly the role of an attorney general and what we are dealing with respect to these issues involving life. I actually have some ideas at the end that I want to propose to you with respect to some maybe new fronts that we need to consider that we've talked about in our office. But first let me begin that many think that with legislators and the legislature, the respective legislatures across the country that attorneys general are automatically the legal advisor of those bodies or those individuals, and that's just simply not the case. In Oklahoma, unfortunately, my office is not in a position to automatically and formally and required to provide analysis around the constitutionality of the law. It's very informal, and that's troubling. And I would say to you that in the various states across the country, the more that you can do to have your attorney general be involved with the pro tem, the speaker of a legislature, and the governor in the preparation and the adoption of legislation, it's important, because at the back end, who's defending it? The attorney general. And so it just makes sense that the attorney general should be involved on the front end. In most states, that's not the case. Now, in our office, we've been very aggressive. We've got leadership in both the Senate and the House and the governor's office that we have great relationships with, and we work with them consistently. We worked with them on both the Nova and Nova 1 and Nova 2 cases, the ultrasound case, and the other matters that were on their way up to the Supreme Court. We worked with them and gave them advice and counsel. But let me say this to you also. It doesn't matter how good a job you do at drafting legislation. It doesn't matter how good a job as far as the cohesion and the work that you engage in from an AG and the legislature and the governor. You could have the most constitutionally pristine and sound piece of legislation that ever was drafted and adopted, and it's still going to be challenged. We start, and you should start, from the premise that every pro-life piece of legislation is going to be challenged. In fact, Nova and other organizations travel the country, and they do this in Oklahoma, and they threaten and they intimidate and they actually say in advance, why are you wasting time passing these laws? They're simply going to be declared unconstitutional. And I will tell you that even in places like Oklahoma, and I think the individuals in this room from AUL and others would tell you that even Oklahoma, there's some persuasion there. The opinion leaders and the editorial boards and the newspapers and the media overall start questioning legislators and the governor in our office on, why are you wasting the state's money advancing legislation that ultimately is going to be declared unconstitutional by a court? Now, that's a false statement, but that's where they begin. And so it makes it much more incumbent upon those that are passing laws to do so with a commitment, a rigorous commitment, to dot every I and cross every T, and to make sure that it's prepared for that challenge when it comes. So things need to change at the state level. Things need to change across the country, but particularly in Oklahoma, we don't, for instance, we don't make a record. Oklahoma's not Washington, D.C., and most people in Oklahoma say, thanks for that, that it's not, in light of what's going on in Washington, D.C. these days. But one of the things that happens here that is good in the adoption of policy and the passage of laws is there's a robust record that you can look at and determine what was the intent of the Senate, what was the intent of the House, what was this particular piece of legislation intended to address. And it is very important for states with respect to pro-life legislation to take an approach of identifying legislative intent up front and making a record in the committee process, particularly with scientific backing and data, medical data, and the intent that it's supposed to address as far as the legislation. It's very important. And it's not happening in Oklahoma, and I don't think it's happening across the country. So that's one of the things we're encouraging our legislators to do, and they're responding because it does give us something to defend on the back end. The other thing I think we need to recognize in this room today is that the strategy being implemented by the abortion industry is very creative at this time, in the sense that they are developing a state-by-state strategy, not just to come in and through media and through intimidation or communication to basically say don't pass any state laws, but they are challenging the statutes that are passed, not in federal court, but in state court. Now think about that for a second. The whole analysis that you've heard today so far from the professor and before was based upon Supreme Court jurisprudence. What is the state of the law? How do we respond to it? How do we pass statutes that conform to the issues that you've heard today or the tests that you've heard today? But the abortion industry has opened up a new front. And the new front is we're going to disregard the entire federal landscape and go state by state to establish what? a constitutional right to privacy under state constitution, a greater right than what exists today under federal law. How do we know that? That's what happened in Oklahoma. The case that was on its way up to the U.S. Supreme Court was a case that was actually filed in our state court. It was not filed under Planned Parenthood versus Casey and all the following cases. It was a claim that said that our state constitution in Oklahoma provided an unfettered, unqualified privacy right to an abortion. And you know that the federal constitution is a floor. So states can obviously provide additional protections beyond the floor of the U.S. Constitution, and that's what the abortion industry is arguing. And that's what they did argue in the Nova case. So this battle is very important because we have to be prepared to respond to that. So what does that mean? Judicial selection. You heard the professor say that who you elect as president matters on the pro-life front, and it does. But I would say, too, it equally matters who you elect as governor in the various states. You need to look at the judicial selection process in each of the 50 states and ask yourself, what is the makeup of the court in those states? Because that front is being opened up, and we may see, what if Roe versus Wade was overturned tomorrow? But yet the abortion industry was successful going state by state in advance of that, establishing a state constitutional right through the various Supreme Courts across the country. So as an AG, we're on the front end, hopefully, most of the time. We're there to encourage them to make a record and to establish legislative intent with respect to defending that law on the back end. We're there to obviously defend those laws as they are passed, because that is our responsibility as the chief law officer of our respective states. And we're there to hopefully be involved in the judicial selection process, giving voice to our citizens across the state of Oklahoma and other states on why it matters, who serves in that role at the state level. But there are a couple of areas that I would say to you that I think are also some new opportunities. I'm encouraged when Justice Kennedy says, look at opportunities with respect to advancing the interest of women. One of the primary responsibilities of an attorney general, as you know, is the enforcement of consumer-related statutes. How did the lady show up at the clinic to begin with? How did the young lady or the woman show up at the clinic to begin with? What marketing, what representations were made to encourage her to be on site? And who processed her when she arrived at the clinic? And was it fair and honest what she was told, or was it deceptive and misleading? And so one of the areas that I think we need to look at on a prospective basis at the state level, particularly from an attorney general perspective and enforcement of consumer-related statutes, is what can we do to strengthen our consumer-related statutes as it relates to abortion, as it relates to the marketing that is actually in the marketplace, as you know, to encourage individuals to obtain abortion. And it goes beyond informed consent. And that's one of the areas we're looking at in the state of Oklahoma as far as trying to strengthen that. And then obviously one area in addition is the clinic experience in itself. You know, from outpatient surgery, outpatient procedures versus what the responsibilities are by rule for hospitals in the respective states. So advancing very tight controls on disclosure and also the clinic that's providing the abortion, making sure that informed consent and the safety and health of that clinic experience is advanced with respect to the process itself. So those are some new opportunities that I believe exist that we need to explore from a consumer perspective, as well as from a Department of Health in the state of Oklahoma and other states across the country. And I would just close with this. You know, these areas, I don't want to understate the threat and the intimidation that and how much that plays in whether laws are adopted in the first instance. I said rather quickly that even in Oklahoma, that these groups come in and offer this type of, why waste the time, why waste the state's money in passing laws that you're going to have to defend in the court process. And there are some in the legislative bodies that are starting to listen to that. When you have tight economic budgets and you have all that we see going on from a budgetary perspective in D.C. and that flows through to the states, those that aren't truly motivated by the burden of advancing life, they start thinking, economically, and they start thinking very pragmatically. And these groups know that, and that's the reason they come in and say, don't pass any laws, don't expose the state to that type of liability potentially, because it will cost the state money. You have to respond to that from a public policy perspective and from a government relations perspective. You've got to help those individuals understand that it's not whether it's a sound piece of law that's been passed. It's not that they have failed to do a good job in making a legislative record. The challenges are just going to come. And you have to be accepting that the challenges are just going to come. In the state of Oklahoma, we don't hire outside counsel. It's me as Attorney General and my solicitor that defend the state statute. And I pray we do it well. It's our job. And so when people ask me that on why are you wasting the state's money in defending these statutes, why aren't you telling the legislature to take a different path, my response is twofold. One, because it's an important concern in the first instance. We ought to be advancing life and doing our job from a state policymaking perspective. But as Attorney General, we exist to defend that which the legislatures have passed. And I want you to know that as long as I'm Attorney General in the state of Oklahoma, not only are we thinking about ideas that can be put forth to the legislators to advance the state's interest and the role that we play, but we're going to say unapologetically, we're there to defend that which the policymakers do. Teddy Roosevelt had a great statement one time. He said, in any given situation, the best thing you can do is the right thing. The next best thing you can do is the wrong thing. The worst thing you can do is nothing. I'm thankful that I'm in a room today of folks that say we're going to charge the hill. Keep charging the hill. It matters. It matters to the life of the unborn. It matters to women. It matters that we work and collaborate together. And it matters that we have a multifaceted strategy in responding to those that are seeking an unfettered, unqualified, abortion on demand perspective with respect to these issues. We need to fight back, and we are. And I thank you that you allow us to walk with you, and we look forward to doing that in the future. Thanks very much.